Hello, good morning. My name is Jamal Khan. I'm a senior tax partner at Churchill Tax Group. Today I will be talking about Code of Practice 9 tax investigations, which are also known as Contractual Disclosure Facility. We've got quite a big crowd in the audience today. Because this is a very popular topic, and I hope I can be of some use to some of the audience or their clients. Right, so I'm going to start the presentation now. So, this is once again Contractual Disclosure Facility or Code of Practice 9 Tax Investigations. This is a little bit about us. So what is a Code of Practice 9? It's there are a couple of types we will discuss. There's prompted Code of Practice 9, there's unprompted, or we can call it voluntary. And what's the beginning, the middle, and the end of these investigations. We call it Contractual Disclosure Facility because it gives the taxpayer immunity from prosecution. So we look, and essentially Code of Practice 9 is when it's based on deliberate behavior. Somebody's been committing tax fraud for a period of years. HMRC will normally consult within the departments, carry out some research, and do some background homework on the person, and then once they're pretty certain that this person has been committing tax fraud, they will issue a Code of Practice 9 letter or Contractual Disclosure Facility letter. And the letter says, well, we are aware that you've been involved in tax fraud. It's a fairly scary letter that comes in. And we are giving you the opportunity to come clean. If you admit that you've been involved in tax fraud, you have 60 days to respond and to accept or deny. Right. So if you want to accept, then we look at something called the outline disclosure report, and or you could deny. But if you deny, you can be prosecuted. So majority of the times we expect our clients, or we advise our clients to accept it to avoid prosecution. And even if, for example, there's little tax to pay, but still accept so that you don't get prosecuted in case you didn't cooperate with HMRC and denied. So you have 60 days if you want, in case of a prompted disclosure, and if it's voluntary, for example, sometimes we get approached by customers or clients who tell us that, okay, I've been doing something wrong, but I want to put things right and I want to make a full disclosure to HMRC, and then we get a voluntary disclosure in place. And then HMRC issue a COP 9, and then we have the 60 days. So that's a process that we need to follow. If you deny, obviously that can be quite costly. It can have you can be prosecuted, and HMRC can penalise you significantly higher in case you deny that you've been involved in tax fraud. And once you admit, as I said, we submit an outline disclosure, a report to HMRC, and the disclosure report has to be outline disclosure report has to be drafted very carefully. We consult with our client. We have long meetings with our clients normally before we submit an outline disclosure report. We do receive quite a few Code of Practice 9 investigations from the general public, and a lot of referrals from accountants and solicitors. We spend significant time in that, preparing that outline disclosure report to make sure we don't, because if the outline disclosure report is not complete, that means the CDF or the Contractual Disclosure Facility does not apply, and that means the client is open to being prosecuted. So you have to be very careful. So once we've submitted the outline disclosure report, in which we cover essentially background of the client, businesses they carry out, and where there have been irregularities in their business affairs, where they feel the tax has not been paid correctly or they have not been paying at all, and we make a full disclosure in the report, outline disclosure report. So we submit that to HMRC. HMRC then has 60 days. HMRC then reviews it essentially. We submit that within 60 days. HMRC reviews it, and if they're happy with the outline disclosure report, they will say yes, we accept it. Okay, so now you have immunity from prosecution, and the next step is to have a meeting with HMRC, the opening meeting, the beginning, and then that is quite a formal meeting we have with HMRC. Goes on for a couple of hours. The taxpayer has to be present, is normally present, and we go through a series of, the HMRC have a series of questions. Large number of questions that they ask, and then we set up a plan on how we're going to be handling the investigation, who's going to be doing the work, what work is going to be done, and then we set milestones. So this is a kind of a scoping meeting, that's what we call it. So we set the kind of work that needs to be done based on the outline disclosure report that was prepared, and then we have regular catch-up meetings with HMRC after that, once that's been done, to see where we are in terms of the milestones that were agreed with HMRC. And then once all the work has been completed, we prepare a detailed report for HMRC, and that report covers goes back, say, as long as 20 years, covers all the businesses the client has been running, and where there have been discrepancies, and we quantify those discrepancies. We prepare a tax summary for those discrepancies, and we also prepare how much penalty should be charged based on the behaviour. Because the Code of Practice 9, the penalties are usually quite high, but we have seen many cases, we have been involved in many cases and represented many clients where we've been able to reduce the penalties to very basic penalties, or in some cases we've had even no penalties because the mistakes that were made were not deliberate, and the client had taken professional advice before submitting his returns. So there are cases, but every case is different. HMRC can name and shame people if the tax owed is more than 25,000, and there are deliberate defaulters, but HMRC normally name and shame them. Okay, and HMRC, once we've submitted the report, once again, HMRC will review the report very carefully, and they review every part of the report, and then they can come back either to say, yes, we're happy with the report, okay, and just please pay the tax that you need to pay. What normally happens, what we've seen, is the HMRC will ask a number of questions in relation to the report that we have submitted, and then they will want to verify and quantify and maybe renegotiate some of the amounts that we've entered in there. So that can take a while, based on my experience. I've been doing this for a very long time now. And HMRC, sometimes the report, once the report has been submitted, it can take anything up to 2 years, 3 years to agree on the numbers, because HMRC the HMRC officers in the Fraud Investigation Service, or the FIS team, will ask. They're very intelligent, and they will want to understand what is being put in the report and if it's logical or not. So you have to be very careful when you draft that report. So that report, once the report has been agreed upon and changes have been agreed, then yeah, HMRC will conclude matters. In general, the COP9, the entire COP9 process takes between 2 and 7 years. It can be quicker than 2 years. It can be maybe 12 months, but there are fewer of those. 18 months, yeah, there are fewer, but generally between 2 and 7 years. It can go up to 10 years, because some of the information that's needed could be very difficult to get. But yeah, that's about it. If you have any questions on these Code of Practice 9s or Code of Practice 8 as well, or other tax investigation matters, do contact us, and we'll be more than happy to help. We do this every day. We do these investigations every day, so we're very familiar with the process and how to mitigate the tax and how to negotiate with HMRC. Thank you very much.